This program is made possible by the New York law firm of Zalman and Storman, who specialize in the field of personal injury law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. Many couples are uncomfortable with the idea of planning the dissolution of a marriage before it even begins. Today we'll look at prenuptial agreements, see who should have them, and why it can prevent unnecessary litigation in the event of a divorce. Our guest is Stanford Lotwin. Stanford is a matrimonial attorney with the firm of Tenzer Greenblatt. His client lists include Donald Trump, Joan London, and Robert Duvall. Stanford has practiced matrimonial law for over 35 years and is an active member of the American Academy of Matrimonial Attorneys. Hello, Stanford.
Hi.
Stanford, what is it like representing people like Donald Trump, Duvall, Joan London? I mean, it must be certainly a lot different than representing the normal working class person.
Well, they of course are very interesting people because they've achieved a great deal in their particular goal. They also are all very driven people. But we found that there are also people that will cooperate, that will listen to their lawyers, that will take advice. And I think they all feel if I'm going to a professional, I'm really going to be guided by that professional.
Now, I remember reading about the Joan London divorce. It was all over the newspapers, and the New York Times said, I know that was settled, but the resolution of that was something that she actually had to pay him money. Was that correct?
Well, in New York, the person's celebrity status is deemed to be an asset. Since Joan, during the course of her marriage, rose from a street reporter with Eyewitness News to probably now the longest-running anchor in morning television, that had a value. I can't discuss the details because we do have a confidentiality agreement, as we do with many of these celebrity cases.
Are you are you saying that the husband received, in that case, as it was a part of equitable distribution, part of her fame?
Well, let's say that a number was put on her fame, and call that either enhanced earnings, call it celebrity goodwill, and there was a settlement based upon her future earnings, as there is with a doctor or a lawyer, anyone who has a license.
But isn't it a little different for an entertainer? Because if they break a leg tomorrow or they get sick, certainly what happened to the celebrity status?
Well, of course, that's an argument that we made, and we didn't go to trial, so it wasn't tested, but wouldn't a lawyer say the same thing? He says to his wife, I may never get another case. Or the doctor says, I may decide now to drop out. Probably the most famous case in New York is O'Brien. O'Brien was a doctor who, at the very end of his training, when he was a resident, decided, goodbye, Mrs. O'Brien. There were no assets. She had put him through school, and this was the beginning of enhanced earnings. So the court said, you do have an asset, doctor. Your asset is the license you've acquired during the marriage, and we're going to value that license based upon your enhanced earnings. What would you have earned as a college graduate compared to what will you now earn as a doctor?
So that translates as far as being an entertainer in Joan London's case as well.
Well, it's translated all the way down the line. If during the marriage you've gotten a master's degree, and the court says, okay, now with a master's degree, say an MSW, you could earn $10,000 more than if you just had a bachelor's degree.
Okay, let me ask you this, and again, getting back to the Joan London matter, because I know we're all familiar with it because of the newspapers. Does she actually have to pay maintenance for the husband as well?
Well, you really are putting me in a situation that I can't discuss.
Because it's private, is that what it is?
Joan London's situation, because we've all agreed that we do, and we really do abide by these confidentiality agreements.
But are there cases where wives actually have to pay maintenance to the husband?
That I certainly could tell you that it's based upon need. It's supposed to be gender neutral, and it really is gender neutral, so that we have cases where women who are the moneyed spouse,
Right.
who have the greater earnings, do now contribute to husbands who have either less or no earnings.
Okay, now we talked about prenuptial agreements. If they had a prenuptial agreement, would this had taken care of that?
It would have, and now you've really got to the crux of where you would want a prenuptial agreement. You're a professional, and you either have a going practice, husband or wife, or you're starting in the practice. And the one thing you don't want in the event you get divorced is a partner. You don't want somebody coming in and say, okay, I'm going to bring in my forensic accountant, and that accountant is going to estimate what this practice is worth based upon your revenue. In addition, the accountant is going to say, how are you cheating Uncle Sam? Are you charging off certain business expenses as personal expenses? What are the add backs? Is there a cash component? And what makes it so difficult, and this is why the premaritals are so important, is that you've got to buy your spouse out. There's no tax advantage. You can get a practice worth $1 million. You pay $500,000 net, and at the end of the day, you have exactly what you had at the beginning
But
of the day.
Stanford, let me ask you this. I know you handled Donald Trump's matter. I know you represented him for the years that the matter was pending. He had a prenuptial agreement, yet it still resulted in litigation.
He always says that to me. He had a prenuptial agreement. I'm very happy to report that what he ultimately paid was exactly what the prenuptial agreement provided.
What happened to the years of litigation that
Well,
we read
the years
about?
of litigation is the fact that you can't guarantee that an agreement is not going to be attacked. I mean, we tell that to an agreement to a client up front. A prenuptial agreement has to be like a fort. You build a fort to resist attack. You should negotiate and structure this agreement also to resist attack.
Are you saying he paid that settlement that I think I read it was something like $25 million?
Something like that.
Only
or take.
because it was, give or take, $1 million. Soon we're going to get into serious money. Because of the agreement, or because it was rumored at that time, or at least he showed the media that he was overextended at that time?
No, because of the agreement. That's the point of the agreement. The argument of the agreement is that it gives certainty. It gives a woman certainty as to what she will get, the man as to what he will pay.
But wasn't Ivana Trump saying that the agreement was not really an agreement and should not be upheld?
What she said, and which is said quite often, is that the agreement at the time it was put into effect was now unconscionable based upon the totality of the circumstances. These agreements, all of them now, have to pass two tests. Was it fair and reasonable when you signed it? In most cases, if you had your own lawyer and there's financial disclosure and you read and write English and there's no duress, the answer is yes.
Okay.
The harder test is 10 years later, 15 years later, is it now unconscionable? And that's where people run into problems. They have lawyers who really don't understand this field, and they engage in what I call overkill.
Oh, when you say unconscionable, is that term? It shocks the conscience of the court?
Yes, it shocks not only the conscience of the court, but any rational person's conscience.
Did she have a lawyer? Did Ivana Trump have a lawyer?
Of course she had a lawyer.
And did the lawyer go over the numbers when I assume?
Well, I'm telling you that Ivana Trump's document did not shock the conscience of the court. I'm talking about a situation, we see it all the time, where someone comes in, the money spouse, and he says to me, Stan, I have nothing to worry about. I have a premarital agreement. And I read the agreement, and the agreement is a series of waivers. I waive maintenance. I waive distribution of property, which we in New York call equitable distribution. And when I leave, I get my false teeth, maybe. Now that is shocking if during the course of the marriage, this man has acquired millions or tens of millions or hundreds of millions of dollars. He says, no, it shouldn't be shocking. She knew what she was signing. And most of the time, she's had an attorney. She does understand it. And I keep saying she, but it could be he, she.
I understand, but more of the times than not, it's the wife and the husband.
And we get married always to stay married. Nobody ever gets married to be divorced. With this great hope and this great love, and then something happens. And now I tell women who I represent, when they're presented with these agreements and they love these men dearly, and I tell them what a bad agreement this is.
Right.
And I said, and when the marriage, and if the marriage goes bad, there are two people you're going to be angry with. The first is your husband, and the second is me. No matter what I tell you, you'll say to me, you should have blocked the door with your body and not permitted me to sign it. And I understand it. I could tell you there are many matrimonial lawyers who say, I won't represent people in these agreements. It's much too difficult.
Stanford, let me ask you this. let's assume the husband is a big earner, and the wife basically doesn't earn anywhere near what the husband has nowhere near the kind of assets that the husband, potential husband has. Mm-hmm. Can they enter into an agreement right in the beginning where she waives maintenance?
Okay.
Where she waives any right to equitable distribution of the assets they acquired during the marriage?
Let me break that down into two parts, because it really
and maintenance is like the old alimony, right?
It's a double answer. That's right. I used to say, until I was booed off a stage, that women liked the money, the alimony, but they didn't like the name, so now they changed it to maintenance. But no man ever felt better about writing a maintenance check instead of an alimony.
Same thing.
I don't tell that story anymore,
okay.
Except on television.
Okay.
When I represented Trump along with Jay Goldberg, who's a noted trial lawyer,
I know Jay's been on the show.
We read every case in the country in reference to premarital agreements. And there's an interesting pattern. The courts will really allow you to waive equitable distribution, the division of property. They're very careful about the waiving of spousal support, maintenance, alimony, because of the fear that the spouse will become a public charge. And that's the interest of the state in looking at these agreements.
Ivana Trump was not becoming a public charge by any means.
But what you have here, and put Ivana Trump on the side for the moment, is that if you represent a man, you should really say to him, be very leery about a maintenance waiver. Provide something, have it increase percentage-wise based upon the years,
something
based
within
upon
reason?
income. Something within reason. Could be far less than any court would give, but not a complete wipeout.
But the spouse can waive the equitable distribution. She can waive a portion of the assets, a share of the assets. That can be waived.
Again, I will tell you this. It's interesting. There are not a lot of cases across the country that test big settlements. You've got a lot of cases that deal with people of moderate means. You don't see the tens of millions, $100 million cases because they get settled.
Stanford, in a matrimonial matter, you become very close with your client. It's almost a very...
Well, not as close as before the new rules.
Yes, we'll get into that.
Right.
But it's a very intimate, very personal relationship. Would that be fair? Tell us a little about Donald Trump. What is the man really like?
Well, I have to tell you that it sounds odd to say it, but both Jay and I really enjoyed the case. We enjoyed Donald. We found, certainly is a genius in what he does. He was always good company. He was very good-spirited. And the most interesting thing is he only had the most positive things to say about Ivana from beginning to end. Their marriage had ended. They had these 3 children in common. He recognized the contribution she had made. So to this day, and I continue to see him, it's refreshing to see people go through the most public divorce in the world. I mean, 11 days they were on the front page of the media without feeling that they had to tear each other down simply because whatever the magic is in the marriage went out of it.
When you're with Donald Trump, do you feel you're in the presence of somebody who's dynamic?
Well, I have to tell you, being with Donald Trump is like being with the old Hollywood stars in the 40s. When you go with him, there's a crowd, and people want autographs, and there's security, and there are cameras, and so the answer is yes. You really do feel the difference.
Well, how do you deal with Donald Trump, and how do you tell Donald Trump, no, you're not doing the right thing? Let me tell you, that's not my recommendation. How do you change somebody of Donald Trump's demeanor, who handles not tens of millions of dollars, but billions of dollars? How do you deal with that client? How do you make him basically see why your opinion and the law should really prevail?
Because if he doesn't respect your opinion initially, he shouldn't retain you. Because he has been successful because he's been guarded by people who allegedly know what they're going to do. And one of the jobs of any good lawyer is to fight with their own client. We're not supposed to be rubber stamps. We're not supposed to tell a client what he or she wants to hear in any situation, whether it's a premarital or a settlement. And even though the client may say at one point, as they all say, you're not on my side, the reality is when you fight with your client, you are on their side.
Now, most matrimonial matters, of course, don't even reach the public, don't even reach court. Don't they usually are settled between the parties or settled between 2 professional attorneys?
the great majority, even those that go to court, never reach trial. They're settled somewhere within the litigated system. The system would completely break down. It's like the criminal system. They have plea bargaining. We have settlements.
We have to take a break now, but right after the break, I wanted you to tell us, maybe you can fill us a little intimately, why the Donald Trump matter, how to actually reach court, and why it wasn't settled before. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
After dating the guy forever, you think I could tell him anything.
Why is this so hard? I'm really scared.
It takes a lot of guts to tell someone he's too drunk to drive. But you can do it. Just say it. Because if you don't, there may be nothing left to say.
Kevin, I'm gonna drive.
Take the keys, call a cab, take a stand. Friends don't let friends drive drunk.
When your employees train with the National Guard and Reserve, they learn to be better team players, better decision makers, and better leaders. It's training that makes them better at serving our country. And better when they come back to work for you.
Bill's back.
Be a hero. Give your employees the freedom to protect ours.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're discussing premarital agreements, matrimonial law, with a very well-known matrimonial attorney, an attorney to the stars, to the rich, to the famous, Stanford Lutwin. Stanford represents Donald Trump, Joan London, and Robert Duvall. Stanford, right before the break, I had asked you, why is a matter like Donald Trump, why did it have to reach court? Why couldn't all the attorneys sit down and over a couple of days work out a settlement?
Well, remember, ultimately, we did work out a settlement.
Only with the help of the court.
The settlement. Judge Gangel Jacobs was of great help to us, and she worked very late on many nights, really in her own time, as good judges do.
But why did it have to go that far?
People have different agendas. Our agenda was, remember, Donald Trump had negotiated an original agreement, an amendment in an agreement, an amendment of the amendment. This agreement had been changed.
The two amendments, were they changed before the marriage or during the marriage?
The two were after the marriage. It was a premarital and what we call two marital agreements, each time increasing the amount so that the agreement grew as his success grew, as his wealth grew, as her needs grew.
What, does that mean the wife comes to her husband during the marriage and saying, wait a minute, you're making a lot of money here. I'm not really happy with that agreement that we entered into before we got married. Oh, does the husband have to say, well, let's increase it?
Well, no, he doesn't have to say it legally, but if he loves this woman and he wants her as a very loving wife, yeah, he really does, because these things are constantly negotiated. I have any number of agreements where there are modifications.
During
where the woman
marriage.
says, listen, we've been married now 5 years. You know I'm a good, loving wife. I'm very insecure about the fact that the apartment, which you had before the marriage, is still only in your name. I want to have some feeling that at least on your death, forgetting about divorce, but on your death, that your kids by your first marriage are not going to put me out of the apartment. It's a real concern. A loving husband recognizes that concern, and he's going to give her peace of mind.
So in other words, even though it's an agreement written before the marriage, like in Donald Trump, it can be modified during the marriage.
Exactly. It's just a modification of a contract, and we simply call it a post-marital agreement instead of a premarital agreement.
But what's the consideration during a marriage for something like that? What's the consideration for a husband saying, all right, I'll give you another, another couple of $1 million?
The most important consideration, and that's the continuation of a smooth, happy marriage when somebody feels they haven't been treated properly or that they need the emotional support of this agreement. Particularly, we haven't at all talked about the death provisions of these agreements, which is major. Everyone concentrates on divorce. But for many years before we changed the laws in 1980, premarital agreements could only deal with what happened on death and the waiver of what is known as a right of election, the right to take a third of your spouse's estate, no matter what he or she may leave you.
Well, wait a minute. If Donald Trump had died, could have Ivana Trump taken a third of his estate?
No. Because in these agreements, a major part of the agreement is either a complete waiver where one, they both say to each other, I have no right under the estate's power and trust law. I only have the right of what you give me. It's called a waiver of the right of election. So what they normally have in all these agreements is a sliding scale. Instead of an immediate 1/3 when you leave the wedding ceremony, the third is either set in a dollar amount or the percentages build up year to year till you reach
Stanford,
the
let
third.
me ask you this. What happens in the case where a couple is dating, and again, the man's a substantial man, and the woman basically is a working class woman, and they enter into a prenuptial agreement, and he says, well, you know, I have a couple of $1 million. And a couple of $1 million to him really means he's got like $25 million. He's really rich. He's got assets from New Jersey right to Florida. But, you know, he doesn't want to tell her about everything. He just wants to... So he says $2 million and it means $25 million. And she thinks he's... You know, she's not going to ask to look at his books. She's not going to send her accountants in to audit what the properties are really valued at. I mean... And she enters into a good faith agreement. Can that agreement be set aside?
Absolutely, because he's committed a material fraud. The material fraud is, would she have consented if she knew he was worth 10 times what he represents? He has to be a damn fool to do that, because we have a theory called separate property, meaning what you enter into the marriage with, you keep in a divorce. It's a very complicated theory, but certainly one thing you don't lie about in a premarital agreement is what you have.
Wasn't that one of the things Ivana Trump was saying that Donald Trump had committed?
Oh, but there was absolutely zero basis.
That's what the paper said.
Look, they said everything, including they didn't like the color of the paper that the agreement was written on. But what she said and what the realities were are two different things. There was absolute, full, complete, honest disclosure.
Now, I know you represented Robert Duvall, and I think that was a little differently. Was that settled?
That was settled.
And was it settled amicably between the parties?
It was.
Did it reach court?
Not close, no.
It wasn't even close. Now, what made that different than these other high publicity cases, like Joan London, which reached court, Trump, which reached court, and now that one you handled differently and it was settled outside? What was the ingredients of that? What can the public know, or how a matter is settled outside of court?
No children. A shorter marriage.
How long was that marriage?
Oh, as I remember, it's 7 or 8 years.
Okay, but lots of money involved.
And
lots of money.
You really sort of touch areas that I can't talk
I don't want to go
about.
into the money, but
there are people who simply want to sell. I mean, I had a case some years ago where they had been married 20 years, and the net worth was something in excess of $15 million, and the client said to me, my wife and I have great respect, great affection. We've had children. We can't, for different reasons, live together. I really want to do the right thing. 8 business days. It will never happen again, but it's just proof that it can happen if people say, we're going to put the emotions aside. We've got to deal with whacking up this marital pot.
Isn't one of the most important factors in settlement of a matrimonial matter 2 experienced matrimonial attorneys?
Yes, combined with 2 rational people. We don't spend a lot of time dealing with people who are rational during this period of their life, and that really is the problem. If you care about your client, you have to do a lot of talking to them about dealing with the realities of the situation, splitting time with the children, splitting the assets. It's easy to say. When you get caught up in it, it's very hard to do.
Now, the Woody Allen matter with Mina Farrow, that's over. Now, I know you do custody also, isn't that correct?
I think all matrimonial lawyers do custody.
Would you have handled, if you had represented Woody Allen, would you have handled that differently than his attorney?
I never would have handled it that way. I think the great mistake is to move for custody on behalf of a father who has spent so little time with the children. I don't think there'd ever been an overnight. I don't think he knew the children's names. He wasn't an involved father. I mean, I love Woody as an artist, but I think the strategy was terrible. It was, we're going to attack before we're attacked. It was wrong. I don't think he ever stood a chance of getting custody, forgetting about the allegations of sexual abuse.
Yet the trial went on for weeks, if not months.
Well, it went on a long time also because it was bifurcated in little bits and pieces. Every motion, which normally no one pays attention to, was a media event.
If he had come to you, would you have told him straight out, if you want me to represent you, I would say you do something different?
I tell that to men all the time. A man feels the greatest attack against his wife is the children. I won't take a case where the man is trying simply to blackmail her by saying, I'm going to get the children.
Well, you're telling me, as a matter of law, from your experience, you have 35 years at the bar, right from the beginning, Woody Allen never had a chance.
In my opinion, no. And I think in the opinion of most people in the matrimonial bar, he never had a chance.
So why didn't his attorney tell him that? His attorney's an experienced man.
Well, I don't want to second-guess anybody else's lawyer, but the reality is, even though the books may say that a father and mother, there's no presumption of which should be the custodian, I'll tell you, in the mind of every judge, I believe, certainly in New York, the presumption is you have to show me why this mother is not a more fit, a more nurturing, a better parent. But putting that aside, look at the facts as they existed in this particular case.
Now, you're one of the leading matrimonial attorneys, not in New York City, but probably in the United States. Now I know in New York State there's a whole new world of documents that matrimonial attorneys have to fill out, affidavits that they have to attest to, retainer agreements. Someone told me that the retainer agreement now between an attorney and a matrimonial client is 10, 15 pages. I mean, what's happening in the matrimonial
Well, I'm going to have a new
bar?
specialty, and that is I'm going to review only retainer agreements that other lawyers prepare. That'll be my subspecialty. There was a perception that clients in a very emotional state need protection against their own lawyers. I can't tell you that I ever join in that. I think the matrimonial bar is a very hard-working, very diligent, ethical bar. In our bar, like every bar in every profession, you have bad apples. Unfortunately, those are the ones that contaminate the entire barrel. So Monica gets a group of people who felt that they weren't properly treated by their lawyers, mounted a campaign which has resulted in all of these rules which ultimately, and you're going to hear this as months go by, result in women of moderate means they're not going to be able to get good counsel.
Why is that?
They can't pay a retainer. If they can pay a retainer, they have to say to the lawyer, I could pay you your initial retainer. The rest of it you're going to have to get when the case is settled.
But I'm sure you know matrimonial attorneys that took mortgages on homes to secure their fees, and the people actually lost their homes when they
I don't know any case where a home was foreclosed. I know of security interests because that's the only way they're going to get paid.
Another thing the rules are trying to prevent actual attorneys sleeping with their clients during the pendency of the matter?
Well, I think that's wrong. It's always been wrong. Just as it would be wrong for a doctor, you should really keep your distance. But if you're going to have that rule, then have that rule no matter what field. Why only matrimonial lawyers? Let that rule apply to all lawyers and all professionals. Don't single out the matrimonial bar.
Stanford, what's your advice to, let's assume the non-working spouse, and let's assume many times it's the woman, she's sitting in our home now, she's watching the show, and she's very unhappy with the marriage, but she knows nothing about the husband's income. She knows he owns real estate, he owns a business, he makes a lot of money, and they live a nice lifestyle, but she knows nothing about the business, nothing about anything else. But she sees the marriage is teetering. What's your advice to her?
Have a consultation with somebody who's knowledgeable in the field. Understand what your rights are. Understand the downside. Understand the problems in discovery if he's someone who has everything on a subterranean basis.
Should she try to get information? Should she look over the tax returns quickly?
Well, the tax returns we could always get. That's not a problem. What she'd be better off doing is looking at the mail as it comes in. Look at the banks and the security companies.
Stanford Lotwin of Tenza Greenblatt, thank you very much for appearing on Lowline. I really wish we had more time. And as always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program is made possible by the New York law firm of Zollman and Schnorman, who specialize in the field of personal injury law, located at 63 Wall Street in New York City.